Bueno, buenos días a todos de nuevo. Ya tenemos a la profesora Herrero que va a hacer la inauguración del evento y, y bueno, vamos a hacer entre las dos, lo vamos a intentar. Y me están viniendo más personas, pero bueno, vamos a ir arrancando para no haceros esperar más. Y sin más, muchas gracias por estar todos presentes hoy aquí online y en presencial unas cuantas personas. Y hoy vamos a hablar sobre mercados digitales y aplicación privada del derecho a la competencia. Y es un honor poder contar con todos vosotros hoy aquí y poder intercambiar ideas sobre el futuro del derecho a la competencia en su vertiente de la aplicación privada y en concreto en mercados digitales, que nos está causando muchos quebraderos de cabeza desde la perspectiva de la aplicación pública, y veremos qué es lo que sucede con la aplicación privada. Y sin más, le cedo la palabra también a Carmen.
Muy buenos días a todos. Disculpa el retraso. Una muy bella universidad, pero un poco laberíntica. Bueno, simplemente comentaros que estas jornadas de hoy en la Universidad de Deusto, que ha sido tan amable de acogernos, se realizan en el marco de un proyecto conjunto. Estamos trabajando en Derecho de la Competencia en dos ramas principales, mercados digitales y aplicación privada, y por eso hemos decidido juntarlos, la Universidad del País Vasco y la Universidad de Valladolid. Y dentro de los equipos de investigación tenemos varios profesores, la Solerno, la profesora Julia Escudero de la Universidad de Deusto. Es una cooperación una cooperación pues, transversal, y intentamos organizar estas jornadas en cada una de las sedes. O sea que es un placer estar hoy aquí en el marco de este proyecto. Si os parece, vamos a dar ya para poder empezar con las jornadas. Vamos a inaugurar esta jornada, luego la clausuraremos más formalmente y vamos a pasar a la primera de las mesas. Bien.
Perfecto. Pilar y Gorka están online. ¿Quieres también?
Y bueno, pues...
no, quédate ahí. Sí.
Muy buenos días a Pilar Canedo y a Gorka Navea. Pues es una situación un tanto extraña, porque yo soy una castellana que tengo que dar la bienvenida aquí a dos personas a su casa. Porque tanto Gorka como Pilar pues han estudiado aquí en la Universidad de Deusto, han adorado la Universidad de Deusto. Pues muy bienvenidos. Como ya sabéis, esta es vuestra casa. Nos encantaría contar con vosotros presencialmente. Tristemente nos vamos a tener que conformar con vuestra presencia online, pero la aprovecharemos al máximo. Bueno, muy brevemente voy a presentarles porque, bueno, vamos a hablar de aplicación privada y de mercados digitales desde distintas perspectivas, como habéis visto en el programa, la perspectiva profesional, tenemos desde la perspectiva judicial y también desde las autoridades públicas. Entonces, en esta primera mesa, en este primer panel, vamos a contar con representantes, Pilar Canedo, consejera de la CNMC, la Comisión Nacional de los Mercados y la Competencia Española, y Gorka Navea, que es funcionario que trabaja en la DGCOM, ¿no? En la Dirección General de Competencia en la Comisión Europea, para que nos cuenten la perspectiva desde el Public Enforcement. Entonces, bueno, una breve introducción y enseguida les cedo la palabra. Gorka Navea también es alumno de Deusto, como he dicho, y de su Instituto de Estudios Europeos. Él es funcionario desde 2008 en la Dirección General de Competencia, ha trabajado en concentraciones, en fusiones, en antitrust, fue jefe de unidad adjunto en cárteles y trabajó en el gabinete de Joaquín Almunia, vicepresidente de la comisión, y ha vuelto, ¿no? Gorka a la casa mater, otra vez a la Dirección General de Competencia, tras una pequeña excedencia, bueno, no tan pequeña, 4 años, trabajando como socio de competencia en un bufete americano, con lo cual conoce muy bien las dos caras, la pública y la privada de este derecho. Y bueno, Pilar, aquí en Deusto no necesita presentaciones, que casi me da vergüenza, Pilar, presentarte en Deusto. Bueno, pues Pilar es alumna de Deusto, doctora por Deusto, ha hecho todos los másteres de Deusto, ¿no? Y bueno, fue presidenta de la Autoridad Vasca de la Competencia, sus trabajos en competencia, pues que son innumerables, y está desde hace 4 años, ¿no? Como consejera de la Comisión Nacional de los Mercados y de la Competencia, la consejera rebelde. Y bueno, pues les cedo la palabra a ellos, que nos van a hacer, bueno, cada uno es una pequeña presentación y luego podemos abrir un pequeño turno de preguntas o de debate para el público, tanto presencial como online. Cuando queráis, Pilar, Gorka, tenéis la palabra.
¿Quién empieza, Julia o Carmen? ¿Empiezo yo o empieza Gorka?
Pilar, si te parece, pues Gorka, ¿te parece bien? No le veo a...
Sí.
Muy bien. Pues si os parece voy a empezar compartiendo una presentación que espero que ya estéis viendo. No sé si la veis. Cuando la veáis, por favor, si sois tan amables, me lo comentáis.
Se ve, se ve.
¿Se ve? Vale, perfecto.
Sí,
Bueno, pues,
perdona, Pilar, se ve perfectamente. Gracias.
Empiezo con el debido y sentido agradecimiento por la invitación. Para mí, obviamente, es un placer volver a casa siempre. Me da mucha pena no poder estar ahí, que normalmente además los jueves no suelo tener problema para estar en Bilbao, pero casualmente hoy había también otro acto en la CNMC y entonces no me he podido desplazar, lo cual me da mucha pena por no poder veros en persona y estar otra vez en casa, pero agradezco mucho la invitación y la posibilidad de compartir con Gorka esta mesa en la que nosotros vamos a dar una visión, como ha dicho Carmen, desde la aplicación pública. Yo en este caso... So I'm going to turn into English because I think that they told me that it was better, right?
Mm-hmm.
Julia? Okay.
Yes, please.
Yeah. So after the introduction, I'm going to deal with those topics that you have there in my little agenda. I'm going to try to describe what we have been doing at CNMC dealing with the digital markets, and for trying to cover all the main things that we have done in digital markets. I'm going to tackle with the two main functions that we have in competition authorities, because as you all know, we deal, at CNMC we deal with regulated sectors, but I'm going just to focus on competition law, of course. But inside competition, I'm going to focus both in enforcement and in advocacy. And in both of the fields, I'm going to develop a little bit the main ideas that are in our mind when we are going to face these disruptive cases. And I'm going to give you the main examples. As you can see in the agenda, when talking about enforcement, I'm mostly going to talk about mergers, because on antitrust, we have had some cases, but they are not so relevant. We made analysis of several cases, but we didn't sanction conducts up to now dealing with digital markets. So I'm going to mostly explain how we focus cases dealing with mergers, and in mergers we have lots of cases and lots of ideas that we are developing when trying to tackle with those cases. And in advocacy, I'm again talking about the main ideas that we have in mind when we try to deal with those fields. And the two main examples, I'm going to develop a little bit of the two main examples that we have developed in the former years on advocacy. And then I have very brief conclusions and one recommendation that goes for our government mainly. So beginning with enforcement of competition law and mergers, as I was telling you, I think that there are some ideas that are relevant and well known by everyone, but I think that it's relevant to underline them before dealing with the specific cases. And our aim is clear. We try to preserve and guarantee and promote the existence of effective competition. And the eruption of new technologies in the digital markets have created a great impact in our society, in our economy, and we need to take this in mind when reviewing how we apply competition policy and how we enforce competition to those digital markets. And when covering those cases, we have realized that there are some features that are common to all those markets. Those features lead us to the conclusion that in those markets there's a natural higher level of concentration, and therefore we need to deal with market power. We have the market power of big operators. Gorka will discuss and will explain us how inside the European Union they are dealing with this, and this will affect all of us, but I'm just going to explain some Spanish cases and how up to now at CNMC we are dealing with this. The main fields where we have covered mergers in the digital economy are those that you have here, and I will give examples of almost all of them. So you see online food delivery, this is the most common we have faced, and then ride-hailing apps and classified websites and online search. So when we deal with those common interrelated issues, we need to consider the first thing, when we are talking about multi-sided markets, we need to define one specific market, or we need to consider both of the markets that are affected by the behavior separately. And this is something that was new when we began facing those cases, and it has been developed by the academy, but when applying it in particular cases, it's not so clear, the definition in lots of cases, and we need to make an analysis, and I think that this is one of the most challenging things that we face when we are applying competition law to this kind of merger cases. And the second relevant point I think we have identified is that we need to consider alternative criteria. I mean, the traditional way of facing this kind of cases is not efficient with those markets. And then we need to consider alternative criteria in order to really consider the implications of the merger in the market. That's not easy because we are talking about new realities, but I think that this is really relevant when we want to obtain an efficient application of mergers. It's sometimes difficult to have this ex-ante approach because you need to foresee how markets are going to develop and how markets are going to evolve, and that's not easy, but we cannot just use like the traditional tools because, I mean, if we do it like this, the application would not be as efficient as we want it to be. And then the third interrelated issue is dealing with data. I think that during the whole day you are going to develop concepts dealing with data and the relevance of data that increases the role of scale and scope network economies in these dynamic markets, and the effects and that the data create, and also the potential entry barriers that the data can imply, are really relevant and are not easy to foresee when analyzing particular mergers. But I'm going to explain more or less how we are dealing with those ideas. When talking about market definition in these two-sided markets, I mean, it's clear we have those two categories of customers that are interacting with each other. And there's a clear interdependence between the two sides of the platform. And focusing in just one of them or focusing in both of them separately may not fully make us understand how the market is working. So this interplay between the two sides of the market is really relevant, and for being able to make an understanding, a clear understanding of how the market is working and how the market is developing, we need to refine and adapt the tools that we traditionally had. And that's something that we face when we are talking about these kind of cases. And I think that the fundamental question, or one of the fundamental questions when we are talking about this market definition, is whether or not, depending on the situation, depending on the conditions of the market, and depending on the structure and the evolution and the players, it is appropriate or not to define two separate markets or just one. And this is something that we face and that we, try to, with different tools, define. And the next point is data. As I was saying, it is clear. I think that for all of us that are attending this this conference, the concept of data is clear and is clearly a valuable asset. It's really relevant. Now we are trying to define what is the nature of this new asset that we need to analyze, and the thing is that we need to define the reason why we are facing a particular merger. And sometimes we need to realize that one of the objectives of the merger is to get access to the consumer information because of the use that can be made with those data. And of course, this is something that has disrupted our approach to mergers, absolutely. We need to take relevant decisions on dimensions that were absolutely new, as the use of zero pricing strategies and the importance of those ecosystems were like the traditional ideas, the company ideas are absolutely outdated, and now the approach, the business approach is absolutely different. So when we measure the market power in mergers, some of you, I think, are not familiar, or perhaps are not so familiar with the Spanish legal system. You know that in almost all the countries, the basic way of measuring market power is the annual turnover of undertakings. But in the Spanish legal system, we also have these market shares of the companies concerned. And this was something that was considered like an old approach to mergers, and it was criticized by the academy several times. And there was a time when it was almost foreseen as something that was going to disappear from our legal system. But the application of those market shares thresholds in the digital economy has shown a very, very efficient result. Of course, we have pros and cons. There's a potential increase in uncertainty for the notifying parties, and this is perhaps the main reason why this was criticized very hard by some of the lawyers, mainly. And this is true. I mean, when you are talking about the annual turnover of the undertaking, this is something that is certain. And when you are talking about market share, you need to define the market and you need to define the share, and that's something that is not so certain. But up to now, we have, I mean, I think that we can say that the appropriate communication, the open channels of communication that we have developed between the companies and the competition agency have created a solution, a very reasonable solution to this problem. So I think that the risk exists, but I think that up to now we could say that it has been effectively mitigated, and I think that this is something that we have to underline, because there are benefits, there are clear benefits in the use of this market share approach to mergers. Because of this different way of making the analysis, we have been able to review some potentially problematic mergers that would have escaped the scope of the traditional approach to mergers. And I think that this is something very positive for society in lots of cases. And we have been able to refer to the European Commission potentially problematic mergers that with the traditional turnover would escape the merger regulation. We have, I included here the main two cases that were referred to the European Commission: Facebook WhatsApp and Apple Shazam. And I think that this is something quite relevant. But we take into consideration, and we need to take into consideration different features and different topics when defining and when assessing the market power. We cannot just base our approach based in those turnovers, because we are talking about markets that can be expanding or very dynamic in nature. We can be talking about barriers to entry and barriers to expansion, or we can be talking about situations where those barriers do not exist. We need to face, and this is something really difficult to do, but I think that it is one of the most relevant things, the effects on innovation that emergent can have, and also the dynamics of the business model itself. And that's perhaps something that concerns me especially, but I think that the regulatory context in Spain is something that we need to take into consideration, because we have a legal system that is not really flexible and not really open to competition in lots of cases, and this is something that we face and that we are concerned about, both in the enforcement approach and the advocacy approach. Of course, when we are talking about advocacy, this is our main concern, but also when we are talking about mergers and enforcement, this is something that we need to keep in mind. And now I'm going to the cases. I'm going to explain the main features of some of the relevant cases that we have been dealing with on digital markets. I will not talk about this one because it is ongoing, and then I cannot say about this. But let's go to the cases that have already been solved. And I will begin with those online food delivery cases. I will begin with this Just Eat La Nevera Roja that was cleared in 2016. As you can see, Just Eat, I guess everyone knows, is this multinational online platform that is offering food services. And La Nevera, Just Eat wanted to buy La Nevera Roja. It's a local rival. And this is a merger that was cleared in phase number 1, subject to commitments. And the commitment that was imposed was for the company, for Just Eat, to remove the exclusivity clauses in contracts with restaurants for a certain period. This was the commitment that was imposed to it. What the analysis that was done was based in those main elements that you have in the slide. You have a sector that was in a substantial transformation. We are talking about 2016. So the rise of the internet and the use of those platforms was beginning in our society. We have, of course, the two sides of the market, the restaurants one side and the end users on the other side. And we have, as I was talking in theory, the interplay of the two sides of the market. And then we needed to take into account the network effects that the merger could imply. And if we would have the traditional tools, perhaps this wouldn't have been done. But with the digital economy, this is something absolutely relevant. So with the remedy, with the prevention of entering into the exclusivity clauses, the idea was to try to avoid the possibility that those clauses could imply in the creating of barriers of entry for new competitors, new platforms that were competing in the same market. Of course, we needed to take into account the market share that both of the companies were having, the thing that both of the companies were close competitors. They had quite similar business models. These were things that were considered, the point that the merged company would enjoy a very strong position in their geographical market. But then the analysis that was made by the agency showed something that was really relevant in the decision taken. That was that the Spanish market, this market was not mature in this moment. And there was a significant scope of expansion as the reality shown after this merger. And this is why we imposed the conditions, and the next merge that we took into account was Just Eat again with Canary. And this is again Just Eat buying another competitor that was Canary, that was a Spanish company, but very local, just placed in the Canary Island in Spain. And the thing is that because some years passed from one merger to the other, the competitive landscape had changed significantly, and the structure of the market changed significantly. If we compare both acquisitions of Just Eat. In this case, the problem was not so much the party's position in the market as it was in the previous one, but the underlying economic dynamics of the market. So the economics of scale that was achieved and the network effects that could be reached by the company. We took, I was not there, but the agency took into account several topics that I underlined here in this slide. It was a fast-growing company. It had a potential to impose certain pressure in the buyer, but the answer given by the Commission took also into account those features that you have included here. The turnover of Canary was really low. This was a company that was not investing in research and development, and the pricing policy was really similar. So the merger was cleared without commitments. The idea was that the operation could not imply, because of the change in the market, could not imply a distortion, a relevant distortion in competition in the market. So this Just Eat Canary case implied that the Commission decided to open an antitrust investigation, which is the one that you have included there, redes paralelas, exclusividad en las plataformas. And there, the idea was to investigate, because of those movements that we were seeing in the market, we decided to investigate whether there was a presence of vertical restrictions affecting competition in this market, and whether those restrictions could imply infringement of antitrust, of competition law. And for finding an answer to the situation, we carried out a market test. And the results of this market test showed that those agreements that we were seeing in this kind of platforms were not creating harms in the market, and that the market was working quite properly, that the newcomers in the market were imposing exclusivity clauses, and that this was not implying entry barriers for newcomers. And then there were no indications to continue with the case, and the case finished like this. I included this last one. It's quite similar, so another Just Eat. So you see that we are seeing a concentration in the market, but anyway, in this case, we consider that the participation of the Just Eat in the new company that they were going to buy was indirect and really small, and this is why we decided to accept to clear without commitments the merger. So we go to a different market. We go to ride-hailing apps, and you have here the Daimler Halo, My Taxi. And again, we have here another merge of those companies that you have there. And the previous approach was that the merge could imply a very strong position of the new company. And we took into account, again, the operation, the putting together drivers and riders. And again, we were talking about a two-sided market. And then again, we needed to make this analysis of the main aspects that I was underlying in my introduction of the presentation. We were taking into consideration that the relevant product market included both taxi service and private hire vehicles. So the connection between those markets was really relevant, and then we considered that we needed to take into consideration that those markets have a clear interrelation, but then we need to use some methods in order to provide a result, considering if we are going to estimate two different markets or just one of them. And then again, we made a market analysis, and then I included here in the slide which were the main elements that we were taking into consideration in order to make our analysis. And the result was that those companies were not considering, I mean, we're not creating entry barriers to newcomers, and that the competition pressure was enough, and this was a market in a very fast expansion. So we cleared the merger without commitments. And then we go to the classified webs and comparison websites, and we have Milanuncios merger. So we have the acquisition by Scripted of Milanuncios, which is this online platform. And here we went to phase 2 in the assessment. And again, the merge was cleared with commitments, as you can see there. Then we have here a market where you have a very disruptive impact of internet and the economic activities of those companies. And the main analysis here was how those online platforms were working in order to give a better and different service to the end user. And then here we considered that we needed to define the market as a single market because of the interoperability of both of the markets, of the two sides of the markets. And then the market that was designed by the CNMC was a single market. So in this case, we didn't consider two different markets, but then we considered the implications of the merger, both in the horizontal and the vertical implication of the merge. And then we made the market power assessment again. As you can see, you have there the figures that were quite high, as you can see, considering some of the market approaches. But then the main elements that we needed to take into consideration, I mean, assuming those figures, is that we didn't have coordinated effects. The parties' shares were close competitors, but they had comparable strategies. And then we imposed commitments, as I told you. So the commitments were quite relevant. But I mean, the idea, the analysis that we make after the merge is that those commitments had a quite positive impact in the market. And then this is the last one I wanted to include in my presentation, but this was a merge. I have another one, sorry. This was passed without commitments. And the last one, this is the last one, is Turnitin. I included this one because I think that we are all quite familiar with Turnitin and the application of Turnitin. So it's those companies affecting anti-plagiarism, those apps that are used so commonly in universities right now. And then the analysis that we made was the implication or the effects on innovation and the entry barriers that were created or not, and the bundling of the products. But the fact that there were potential competition of very big tech companies implied that after conducting the market test, we considered that this was a merge that was, was going to be approved without commitments. Okay, so I go now to advocacy because I'm running out of time. And then in advocacy, just for, the main ideas, what we try with advocacy is to promote better regulation. So with mergers, we make an analysis of a specific operation that is presented to us, and we need to take a decision on a particular case. But when we are talking about advocacy, what we have is a market, is a general market, and we need to make an assessment of how regulation is affecting the market, or how non-regulation is affecting the market, because we can have both of the situations, and how regulation sometimes is not reacting in the benefit of consumers. Now we have in Madrid some demonstrations of taxi drivers that are against the change in the legislation. It's so frequent in our society to face this kind of situations in different fields. When we are talking about advocacy, what we are trying is to understand how the market power is working, how the dynamics of the market are changing because of the digitalization. And then we try to identify inefficient regulations or entry barriers to competition that are created, or restraints created by the regulation, and try to advise the regulator, the ministries in most of the cases, and try to make them realize that some of the decisions that they take, trying to protect very interesting or very reasonable interests, sometimes have side effects that they don't take into consideration. And sometimes we try to advise them to focus on some issues, or to change some legislation, sometimes with a more efficient result than others. But anyway, that's our aim. Try to advise the administration in order to have regulations that are based on the principles of better regulation, and that protect general interest instead of protecting some of the incumbents that are traditionally obtaining good results out of this regulation. The collaborative economy, I think that was like the first issue that was tackled at CNMC or at CNC, dealing mostly with transport and with hotels. But the most recent cases, and those are the ones I wanted to mention, and with this I would finish, are fintech and online advertising. The common features of both of those, well, the three of them, but the most recent, both of those reports, is that we try to focus on the effects on the digitalization on consumer welfare and efficiency, and we tried to underline how a change in regulation could lead to the good, the benefits of competition in those markets, and with those new regulations, variety and quality and good services and availability of the market, without forgetting that those effects also have and pose competition challenges, and those positive effects can also be translated into entry barriers and lead to high concentration levels, as we have seen, and as the European Union is trying to avoid with DMA that Gorka will explain in some minutes. So with fintech, as you can imagine, what we are talking is about this new reality of those new financial services that rely on those disruptive applications that open opportunities for higher efficiencies and a level of personalization and individualization of financial services that could be really efficient and really positive for the clients. So of course, we underline also the risks and the challenges from the competition perspective, and we try to put both of the things together and try to find a balance, which is, of course, not always easy, but I think it's very relevant for all of us to keep in mind both of the things and try to find answers that are trying to find this balance. So the policy recommendations that we included in this fintech analysis was that we should have to try to facilitate these new services, new ways of offering services, that this could be an opportunity to analyze the current regulation and try to see if there are inflexibilities or entry barriers that are not reasonable, and that we should have to create a regulation with a functional approach. So we should have to look for good objectives instead of formalities that sometimes do not reach those objectives. But anyway, assuming the risks of this very specific market, we also recommended the creation of regulatory sandboxes, because in this particular area, those new business models can have also very harmful effects if they don't work properly. So those sandboxes, I think, are a very efficient way of trying to solve this problem, and the fact is that they have been created by the government. And the last example is the online advertising. And of course, online advertising is absolutely new because of those new markets. And again, here we identified benefits and problems, and we presented policy recommendations. I'm going quick because I ran out of time. So you have here, I mean, the size of the market that we are facing, and the positive effects that I think are quite clear: the capacity of personalization, the new players that enter in the market, the new forms of contracts that are more flexible and sometimes better for smaller companies. But again, we have the risks of competition that we need to face, and I mean, this concentration that is huge. We need to face ways of solving this kind of problems. And then what we have again is we have recommendations that help or offer opportunities in order to try to solve the risks without losing the benefits of the situation. So the common practices, and then one of the, perhaps the most relevant recommendation is the first one, is that competition authorities must keep enforcement competition policy, because most of those risks are connected with traditional infringements of competition law. That, I mean, we need to find tools to fight them, but we need to keep in mind all the other things. And then my conclusions are both based in enforcement and in advocacy, but I would say that we, can consider just one conclusion, that is that we need to consider these new markets with new approaches, with a specific and very deep analysis, without, taking into consideration all the pros and cons. And I think that the main recommendation would be to combine competition policy with antitrust and with cooperation between different authorities. And this is everything I needed to say. So 6 minutes more than I was supposed to talk. Thank you very much.
Bueno, muchas gracias, Pilar, por tu intervención. Vamos a dar ahora, si os parece bien, la palabra a Gorka, y una vez que le acabe su intervención abrimos un turno de debate conjunto. Podemos hacer las preguntas a ambos, ¿de acuerdo? Entonces, Gorka, cuando quieras tienes la palabra.
Muchas gracias, Carmen. Muchas gracias, María Pilar, por esta estupenda intervención que ha cubierto muchísimos puntos y en mucho detalle, y que creo que es muy práctica para lo que vamos a seguir hablando el resto del día. Lo primero, daros las gracias. Como habéis dicho, soy exalumno de Deusto y me hace mucha ilusión hablar hoy aquí, aunque sea a distancia. Y bueno, yo voy a hablar del DMA. But I think I'm going to switch to English now, because perhaps this is going to be easier for everyone. And of course, the first thing I wanted to say is that what I'm going to say now is just my personal view. And it's just, this is the usual disclaimer. So this is not going to be the official position of the Commission. It's it's going to be just some reflections, some thoughts, personal thoughts on my side about the subject of today, which you are asking if it's possible to have a private enforcement of competition rules in the digital markets. And I think that the answer from the Commission is that yes, you can have it. It's going to be possible. We are seeing it. We hope to see it more because we think that this is helpful and this is healthy for everyone. But of course, this can be answered at many levels. One of them, on which I'm not going to spend a lot of time, is the enforcement of the traditional rules on competition in the treaty of Articles 101 and 102. And I've seen in the program that other experts are going to discuss this matter, and I think it makes sense because we at the Commission, we are always observers about these matters of public enforcement. Of private enforcement. So I don't want to say much about that. My personal perception is that there is a good amount of private enforcement of Article 101 and 102 right now in the technology markets in Europe. I've seen from personal experience, for example, talking of standalone actions, I've been personally involved in a dominance case before the Dutch courts about excessive pricing of software as a service between two technology providers. This was a case, for example, I'm talking just about anecdotal evidence, but it gives me the impression that more things will be going on and that this will not be the only case about software as a service, Dutch courts, which are becoming a very popular venue for this kind of disputes, something that at the end was settled out of court, but which had a very substantial, initial court part, and this was a standalone action. I think all of us, we have seen all the follow-on damages that are going on in every sector, of course in cartels, but also in technology. I think there are a number of big follow-on claims in the UK in relation to the Qualcomm decisions that the Commission adopted. I think that there are lots of court action and private settlement negotiations as well on the 3 Google decisions that the Commission adopted. So I think that there is a fair amount of private application of Article 101 and 102 on the technology markets. But as I said, perhaps other panelists have a better overview of this, and I'm not going to talk about that. So as we say in Spain, and this comes from a writer from the town of Carmen, from Mr. Umbral, I've come here to speak about my book. He venido aquí a hablar de mi libro, and today my book is the DMA, the Digital Markets Act, which is something that has been very prominent in the news. It is having a lot of professional interest in the doctrine between academics, but also at public level, because I think, as Maria Pilar said, these are very important and very wide questions. These are societal questions. They are not just competition law questions. So these are the things that we are all seeing about, well, ride-hailing apps, about platforms. I think, of course, the key word here is platforms, about shops closing because people buy in Amazon. Let's use some names here. About our personal data being used for purposes that perhaps we were not aware of, things like that. The gig economy, the informal economy, people working for Just Eat and all these platforms. There have been some legislative actions in Spain about this, informal workers. So I think there is a lot of preoccupation. There is a lot of preoccupation on society. And I think at economic level, this is what has caused the proposal of the DMA from the Commission that has been recently approved. There has been a political agreement between Council and Parliament, and now the proposal is in the process of being formally approved. And in terms of legal mechanics, the text is being polished and it will be published very soon. And I think that this instrument reflects that. And the first reflection is that at EU law, this is not an instrument of competition. the legal basis of the DMA, which is this new provision, probably you know that is Article 114 of the treaty. Is not 101 or 102. So it's based on the approximation of national legislations in the area of the internal market. And here I would like to open already a comparison with some other national alternatives, things that perhaps we're going to see later. Of course, the European Union and European law is constrained by the rules on the treaties. So the starting point of proposing a DMA comes from identifying an enforcement gap that traditional competition tools cannot cover. 101 and 102 have been stretched a lot over more than 50 years of practice. And there is a huge body of jurisprudence applying these concepts also in the technological markets, also in relation to platforms. But there are things there, especially if you talk about, these two-sided markets that Maria Pilar was referring to, that they are difficult to define. It is difficult to prove traditional dominance in these markets. So there are things that they are causing harm in the market, that they are causing harm to competitors, actual or potential. They are causing harm to customers, and that it is not possible to grasp with the traditional competition tools. And there is where the rules of the treaty are the ones that are there, and they cannot be changed because they come from the treaty. So you have to start somewhere else, and you have to try to see this not as a competition issue, but as an internal market issue, and use this other legal basis to do something different and something new. And this is where, for example, countries like Germany or like Spain, if they would like to do it, they have a different luxury, because of course their parliament can just approve a law changing the competition law in whatever sense they want. And this is, for example, what Germany did with this Article 19A, which is to say, well, from now on, the competition statute will apply to other things which are not the traditional competition law of unilateral behavior or agreements between companies. The European Union does not have this flexibility. We are a treaty-bound organization, and that's why we have chosen this different legal basis. But okay, so the DMA is starting something new, and it is a very complex piece of legislation, because in a way it's having institutional provisions for its application. It's having substantive rules talking about gatekeepers and about conduct, and it's having also a system of enforcement with fines and with a regulatory dialogue and with commitments and with remedies to make sure that its rules are enforced. So I think that the objective is clear for everyone. There are a number of platforms there, which is what the regulation calls gatekeepers, that they enjoy a lot of economic power and that they need to be regulated. And this is the starting point of the DMA. So there are three provisions there which are very important, and this is where we're going to start talking about the private application of the DMA, which are Articles 3, 5, 6, and 8 of the regulation. So to start with, the starting point of everything is this Article 3, which starts with a declaration of the Commission that someone is a gatekeeper. And for this, there are some objective criteria, which is the number of users, the amount of sales. When I talk about users, it can be both, consumers and professional users of the platform. Is the revenue of the platform? Is the size in terms of market capitalization of the platform? So with this, if you've got this size, and if you are active in something that the DMA call core platform services, which is basically intermediation in the internet, then you are going to be determined as a gatekeeper. And this determination, the Commission will do it. This is Article 3. And then these people are subject to limitations in Article 5 and in Article 6. These limitations are different. In Article 5, there are very clear limitations, you know, very clear, you can do this and you cannot do that. And in Article 6, as the regulation says, what you've got is obligations that may be needed further specification. And here we're talking of concepts that they are known in competition law, like things like FRAND, like, you know, like margin calculations, things like that, that they need, they're a bit more complex. And anyway, there will be, and this is the last important provision in Article 8, a regulatory dialogue between the platforms and the European Commission. And the result of this regulatory dialogue is there will be a decision establishing some limits to the behavior of these platforms, or there would be the acceptation of some commitments given by the platforms themselves. And this works in the way of a pyramid, well, with different levels of enforcement. And at the end, there are also sanctions for if non-compliance of this. And eventually at the end, and this is the nuclear possibility that has been provided, this involves structural sanctions, not only monetary ones. And this is important because one of the key points in the enforcement of competition rules in the last years in the technology sector is that you act ex post. These people have big pockets, so at the end, you know, a fine X years later, even if the amount of it is astronomical, is not going to remedy harm in the market, and is not going to be a huge punishment for these tremendously huge and influential companies. So here, what we are trying to do is something a bit different, something regulatory, something ex ante, and trying to define some rules and some principles. What I've said now, I think, is what everyone can read in the press releases of the Commission, and I think is very, I mean, it's very well known. And here I wanted to give you a couple of thoughts about the private application of this regulation. And I think that this is a matter of general EU law. There are some hints in the text of the regulation about private application. There have been some hints in non-binding documents from the Parliament in the same direction. There is this clear provision in Article 39, which speaks about relationships with national courts, and all of this shows that there is some intention or some idea behind the DMA that it will be applied privately as well. And I think that this is correct, and this is the result of a standard analysis under EU law, because first we are talking about regulation, and of course regulations are directly applicable. So what you have to do is the traditional analysis of the provisions of each article of the regulation and see if it's self-executing in the sense of the jurisprudence. And I think that there, the first thing that you can say is that Article 3, which is about this exclusive power of the European Union, of the Commission, to declare someone as a gatekeeper, well, there the legislative mandate is clear and conditions and applies only to the Commission. So you can say that the most likely answer is that only the Commission will be able to declare someone a gatekeeper, and that therefore this would be the first precondition for direct application, for private enforcement. But then if you look, for example, under the existing jurisprudence to the mandates and the rules in Article 5, which are the obligations to which the gatekeepers are subject, then you see that these are clear and conditional obligations. They are directed to someone which is clearly identified as well, and they leave really no room for interpretation. And I think that it's fair to say that Article 5 would be self-executing and therefore privately applicable in national courts. Then, if you are talking of the other obligations, this kind of second level obligations in Article 6, and here I've got the text of the DMA that is currently with the Juris Linguiste and everyone. Yeah. The title of Article 6 is Obligation for Gatekeepers Susceptible of Being Further Specified under Article 8. There you've got a degree of vagueness and you've got a margin of maneuver that one would say that is not compatible with being self-executing, and therefore these matters, which as I said, they will involve a lot of discussion about what's FRAND and is not FRAND in this sector. For example, I think this would need at least a bit of prior implementation and some prior decisions from the Commission before we can think about direct implementation. And then the last important provision, it's the regulatory dialogue, which now is Article 8 of the regulation, and establishes, all this process in which, and this is really the intention of the legislator, that there is a two-sided dialogue between the platforms and the Commission to identify properly for which areas you are a gatekeeper and which are precisely the obligations that you are subject to and how to implement them. And there we really count on the good faith and on the cooperation of the platforms, of the gatekeepers. And there they can be, as I've said before, very different outcomes. You can go from a commitment to a structural decision to segregate part of a platform or, to ask for a separation of activities. So now, if you leave this behind and then you summarize this, deciding that the model of enforcement that has been chosen is to go for private national enforcement, but to have exclusive public enforcement on the hands of the Commission, then I think that the question would be which kind of things you can do in a national court with the DMA. And I think by the type of instrument, I think we could be speaking more of a, if you want, standalone type of situation, because what you could do is once that you've got this definition of gatekeeper, you can request an injunction in a national court and you can claim the application of a rule in Article 5 to a company already designated as a gatekeeper. So you can ask for an injunction. This would be the first thing. Then the second thing you could ask, and then I think this is important as well. I haven't seen myself anything in the regulation saying that you could not ask for interim measures, which is also very important, because I think interim measures, this is not the subject of today. It is something very important. It is very important in these discussions about public and private enforcement. Is something that the Commission is very interested in. We had the Broadcom example not too long ago, because we think it is very important to give relief in the market, because competition proceedings at Commission level are very burdensome. Due process is very important. They are long, they are complicated, and interim measures, they play an important role in these discussions. And I think that you could go for interim measures in a national court. That's for sure. And then the other thing you could ask at this stage is, after you have had the definition of gatekeeper, if you have under Article 8 a decision establishing, some remedies or some limitations on the behavior of that commitment, you could ask, for national enforcement, to the extent that this is required, in a national court. This is, you could ask for assistance to a national court. And then, of course, this opens the question, which is something that I suspect, but we cannot say at this stage, is that as the DMA is also giving the opportunity of offering and accepting commitments, it may be interesting for the gatekeepers to go more into the direction of involving themselves in a regulatory dialogue and going into the direction of commitments that they are not self-enforcing in national courts than going for a commission decision that would be, easier to implement and to execute if you need it nationally. But of course, we have seen cases with commitments, we have seen cases with decisions in Brussels, we have seen everything, so it's difficult to anticipate. So of course, you've got all these things, and then of course you could have follow-on damages. Of course, this takes a bit more of time, and I think, and again, this is my personal opinion, perhaps the more interesting private enforcement of the DMA would be on the side of asking for injunctions or asking for interim measures, because this goes a bit with the spirit of the rule, which is to say traditional competition tools are not only materially not very adequate to deal with gap situations, it is also that traditional competition assessments, they take very, very long time. And in the meantime, the markets evolve, the markets change, customer welfare is reduced, harm is created, people, competitors are deprived from market access. So I think if you are thinking of this dynamic of, resolving matters and trying to be active in the market, then private enforcement could be an interesting thing. And it goes really with the spirit of this. The same as I can tell you, and after a lot of discussion, which is public, it has been agreed by the legislators not to have a decentralized public enforcement of the DMA and to give only very limited powers to national authorities. There is a role for them in terms of cooperation. And there is a forum and there are some mechanisms. But the decision has been to give this institutional monopoly to the Commission. I think it would be healthy for everyone if we would go for decentralized private enforcement of these rules. And with this, because I'm mindful of the time and perhaps it's good to open the discussion, there is just this Article 39, and it's about coordination with national courts, because of course the first reaction here is, okay, what happens with the risk of fragmentation, especially when we're creating a new instrument without precedents? I mean, when we had the damages directive, when we had a bit of decentralization of traditional competition rules, you already had a body of jurisprudence that you can rely on. The Commission did a lot of guidance documents, and this is not the position yet with the DMA. Of course, everyone is going to apply it at the beginning in a vacuum. So what is going to happen with the fragmentation? I think there, of course, again, this Article 39 codifies what is standard EU law, the duty of loyal cooperation in Article 4, and what is saying to national courts is, look, be mindful of the decisions already taken by the European Commission, and if you are dealing with something that may be dealt in the near future by the Commission, you can stay yourself from the proceedings and wait for that, and you will have, of course, the traditional mechanisms of having an amicus curiae of the Commission, and this is something that internally we're very mindful of. And on the other hand, the national judge will always have the possibility of having a prejudicial question. So that's a bit architecture. I have not spoken much about the rules themselves, but I think they're very clear. I think that they recognize lots of things that you have been seeing in competition enforcement. It's about tie-in, it's about self-preferencing, it's about use of data. Well, by the way, talking about private application, I can see already people raising privacy defenses to some of the mandates and some of the rules in the DMA. This is something that people are using more and more, with not always very successfully, but voila, we leave it there. So, but these are a bit the rules, and with this, I will stop, and perhaps we can have a nice dialogue about this, about these provisions.
Gorka, muchísimas gracias por tu presentación, muy interesante. Y bueno, al menos a mí, quiero decir, una son las dificultades que va a suponer la aplicación en la práctica de la DMA, en la aplicación práctica, ¿no? El resarcimiento de daños. La no aplicación de la directiva en estos casos, al excluirse su carácter de antitrust, al menos a mí ha sido como una vuelta, vuelvo donde empecé, donde estábamos antes de la directiva. ¿Qué vamos a hacer aquí en España? ¿Vamos otra vez a la ley de competencia desleal? No, por ejemplo, ¿no? Y decimos si se ha infringido una norma que regula el mercado. Bueno, estoy seguro de que hay preguntas, hay cuestiones que quieren plantear en el público a nuestros ponentes. Trasladamos. Helmut, sí. No sé si te ve. A ver si...
Thanks for the presentation, Gorka. One fundamental question. I mean, if the DMA as it stands now excludes as you rightly said, the decentralized application and enforcement by the national competition authorities or by national administrations of whatever kind, isn't it a bit contradictory that national courts should have a role in enforcing the DMA? I mean, I can see follow-on damages actions in where obligations are not complied with. But do you see the Court of Sevilla and of Augsburg and of, I don't know what, imposing obligations under Article 5, and this is then a uniform enforcement of this regulation? I mean, I have difficulties with that. Thank you.
Yeah, I think, Helmut, I think you are completely right. And I think that this is a challenge for all of us, to make sure that the system works. To spread knowledge with national judges, and to make sure that we identify the cases and that we are active and that we coordinate well. It's going to be a change. And then in relation to the contradiction, I think it is a contradiction, yes and no. It is a contradiction because, as you rightly said, the intention of the legislator is to exclude, national public enforcement. But on the other hand, the regulation itself does not decide whether private enforcement is possible. This is a matter of general EU law. So if you've got a regulation and the regulation is establishing some clear principles, some clear rules, then by definition, these are directly applicable at the national judiciary level.
Do you remember Regulation 17, where Article 9.3 granted the Commission a monopoly to grant exemptions under Article 1013?
Yeah.
That's the methodology to exclude any direct application before national courts. I mean, you know how to do it.
Yeah.
Same with the gatekeeper.
Yeah. Look, but I think, of course, Revolution 17, it was a different scenario. And then this changed later in practice. And I think that everyone is happy that the Commission lost this monopoly. And I think we have learned from that. And now the point of view is that we are in a much more mature society. The economic operators are much more familiar with these competition matters. And I think, Helmut, there is this traditional view of people saying in the conference circuit, competition cases take too long, you know, because you do a complaint and then 10 years after the complainant has disappeared from the market. And why is this fine useful for me? Because in the meantime, I had to exit. And the Commission picks their cases. And the same thing, by the way, can be said about the national authorities, because, you know, you've got priority assessment, and then you cannot do all the cases that you want to do, and there are limitations of resources. So I think these are questions that they worry a lot of people. I think we are talking about very basic worries of a very large number of economic operators. And to think that only public authorities or only the Commission could deal with that, you know, it would go against the effet utile of the rules.
Thank you. I think we have another question. Could you pass in the microphone to me?
Thank you. Miguel Ferro, my question concerns it's a bit the continuation of this issue, I guess. No? Hello?
Yes.
Yeah.
Okay.
Yeah.
It's a continuation of the previous question, and it concerns the right to damages. You know, it's a little bit strange, at least to me, that the issue was not addressed in the DMA, like it was, for example, in the GDPR. But I wanted to hear your opinion on whether you see this, the evolution, maybe in the case law, the evolution of this being the court saying, look, there's a direct right a direct right to damages coming from EU law. The requisites of that right to damages are governed by EU law, just like in competition law. Is that where we're going?
Yes, I think, again, this is a matter of general EU law. I think this is the Muñoz jurisprudence, right? You know, so I think this is probably where we would be heading. I think you're right, Miguel.
We have another question for Pilar that I need to find.
In the chat.
Oh, yeah, it's there. Yes, sorry. It's from Dennis Feshcock. I hope I pronounced it correct. Digital platforms as well as fintechs are extremely powerful and can affect millions of decisions. Besides that, they are dynamic and prone to apply changes really fast. Should our legislators and competition authorities react faster to these changes? Is a traditional way of regulating and legislating dynamic? Pilar, this is for you.
Yeah, I read it. Thank you, Julia. Well, I think the answer is quite clear. So no and no. This is why we are trying to change our approach in everything. I mean, in enforcement and in legislation, and this is why we have DMA, I guess. I don't think that we only have DMA, and that's a relevant point, I think, because for fintech, for example, I think that enforcing competition law can be quicker, but we need to respect rights of defense of the parties, and this takes time, and also make a market analysis take time. I mean, you cannot make a reasonable balance between protection of the rights of defense and offering efficient solutions and correct solutions if you need to do it really quick. And then, I mean, we can do our best, but still we will face problems dealing with this. And this is why I think that sandboxes are so relevant. I think that the main recommendation, or perhaps one of the main recommendations in our fintech study, is the creation of sandboxes, because I think that this is the most efficient way we have found up to now in order to give a reasonable answer to certain situations. I mean, it's not possible to create regulation really quick. It's not possible to enforce cases really quick, and I think that we need to find answers, because we see the problems, but we need to find solutions. And I think that one of the efficient solutions, I mean, Gorka was talking about interim measures, and I also think this is something really relevant. And I think that when talking about enforcement, interim measures are relevant, and when talking about legislation dynamics, sandboxes are really relevant. But we need to change our approach. We need to be flexible, but this takes time. I mean, if you are quick and you are not efficient, that's even worse. So I think that sandboxes are a very good answer to the situation.
Any further questions from the audience? We have one there from Andoni. Miguel, can you pass a micro? I have another question about sandboxes, but maybe later. Andoni first.
Go ahead, because I'm changing topics. So.
Okay. Pilar, I'm just wondering, how does it work in practice, regulatory sandboxes? Do we already, I know that there are some rules of the Spanish Financial Authority, but what about transparency and access to what happens in sandboxes? Can you give us some light on that? Thank you.
I would love to give more light. So I think that transparency is not the answer given to transparency is not the best one, I'm afraid. And I think that transparency is really relevant because my approach to sandboxes is that they are really relevant, but we need to find non-discriminatory criteria in order to choose them, and transparent analysis of the results. And I think that, we are beginning with everything. So let's see how it works. But up to now, I would say that we should have to focus in trying to find those goals, because up to now, I don't think that we reach them.
Okay. So thanks a lot for your presentations from a former student of Deusto. I just have a small question from public enforcement perspective. We've seen that sometimes digital company, let's say Amazon, is being fined in a country, let's say Italy, for a certain behavior that is identical in all the EU. So simple question, is there any internal guidance either in the CNMC or in another national competition authorities, or either at EU level, to go ahead with same investigations in other countries? Because maybe I'm sure that the Italian competition did a great job. The fine is 1,100 million euros. So maybe we can use some work done there and use it to find in other countries like Spain, where they do basically the same conduct.
Dealing with Spain, I answered. And regrettably, my answer is that, as you know, after cases have been published, we can say nothing.
Okay, fair enough.
I can say something from the EU perspective. I think, of course, when the national authorities, they apply the rules on the treaty, there is always this coordination with the European Commission. And there are, of course, you've got the ECN, which is, here I'm going to do some advertising for the ECN because this is my daily job. That works very well, I find. There are always these forums between national authorities and also bilateral contacts, not only with the Commission, but between national authorities themselves. And I think what we have achieved is a very uniform degree of application of the same rules by all the national authorities. Then, as Maria Pilar said, then the choice of cases and the market situation in each country is different, and this is up to the freedom of each national authority. So,
okay. Any more questions? So I think if there are no more questions, we are going to make a little break to grab a cup of coffee. And Gorka and Pilar, thank you so much for being here with us today. It was a pleasure to have you, your digital presence. So
we want a digital coffee.
Yes, exactly. We will have a digital coffee with you. Thank you so much. We will.